In this video, we're going to be talking about failure to make an effective gift, the every effort rule. And this is part of a few videos where we're talking about the circumstances in which equity will allow the transfer of legal title to occur, even though the formality requirements have not been complied with. And we've looked at the conveyance of land to a minor and gifts made in contemplation of death. And so this is the next video, and it's about the every effort rule. If the donor has made every effort to effect the transfer but has been unable to complete it because of circumstances that they are not in control of, then the court may, following R.E. Rose, complete the gift. So an issue arises in relation to the situation in which a donor has done everything necessary to transfer the title in the property to another person, but where that outright transfer or gift has nevertheless not been completed. The question is, if the donor has performed all the acts necessary to be performed by her to complete the making of a gift, should the donor have been deemed to hold that property on trust for the intended donee from that moment of completing the necessary acts? And it was held in Rose that if the donor had done everything necessary for her to do to make the gift, then equity will deem an equitable interest in the relevant property to have been passed automatically, even if the donee is a volunteer. This principle, it is suggested, is an exception to the rule that equity will not assist a volunteer. So in other words, where a settlor has done everything within his power in order to render a transfer effective, but something has yet to be done by a third party, the transfer will be immediately valid in equity. Consequently, although it will remain ineffective to pass the legal title unless and until the third party does whatever remains to be done by him, the transferor will in the meantime hold the subject matter of the transfer on the trust of the settlement, so it will be held on a constructive trust. And this was established in this case of Rose, which in an earlier unconnected first instance decision, which coincidentally also bears the same name of Rose, was applied and followed. So this is really, really, really important to remember that these are two distinct cases, but both of them are relevant to this area. So this first case of Midland Bank executor and trustee and Rose, is the earlier first instance case, and that this case here of Rose was applied by a second further case later, which was also called Rose, So just bear that in mind that these are two separate cases. So first of all, the first case is this Midland Bank executor and trustee and Rose case, And in this case, a testator had made a specific bequest of shares, but subsequently before his death executed a share transfer in respect of the same shares in favour of the legatee. So, in other words, we have a person making a will, Mr. Rose, and he put in his will that some shares would go to a man named Mr. Hook, which would happen when the testator died. It also said in the will that the shares only needed to be transferred to Hook if he had not received those shares before Mr. Rose died. But before the testator's, and that's Mr. Rose's death, he did execute a transfer in respect of the same shares to Hook. In other words, Mr. Rose attempted to transfer the shares, thus nullifying the need of the operation of the term in his will, as Hook had received the shares before Mr. Rose had died. Now, because these were shares in a private company, its directors had the right to refuse to register the transfer and did not actually register it until the death of the testator. So the transfer form completed by Mr. Rose constituted everything he needed to do to transfer the shares, but the transfer was not complete because there was a further formality to be completed by the company. The issue was whether the transfer of shares to Hook had taken effect under the ineffective inter vivos transfer form or under the terms of the will. So, as mentioned, the completion of the transfer form was the only formality which Mr. Rose was required to carry out as transferor. However, the company's Articles of Association gave the Board of Directors power to refuse to register the transfer of shares. Therefore, the transfer was not complete until the board actually approved it. Whether the legatee had taken the shares inter vivos or post-mortem mattered a lot, okay? This mattered because the bequest in Mr. Rose's will was conditional on the shares not having been transferred to the legatee prior to the testator's death. It was therefore possible to argue that the transfer inter vivos was ineffective to pass any title, but nevertheless sufficient to defeat the testamentary gift, thus preventing the legatee from receiving the shares at all. So, and the judge here, Jenkins, held that because the testator, Mr. Rose, had done everything in his power to transfer the shares inter vivos, from that moment he held the shares on trust for the transferee, Hook. Consequently, the legatee, Hook, had taken the shares inter vivos. Okay, so that is the first case and of Rose, and then in a subsequent second case in the Court of Appeal of Rose in 1952, we have this case of Rose was applied and followed, okay? So we have now another case called Rose, which was a second case following the previous case of Rose, okay? So in this case, the Court of Appeal held that the beneficial interest in shares was passed to the donor's wife when he had done all that was in his power to transfer the shares, not at the point when the shares were registered in the donor's name, which is when legal title passed. Okay, so in this case, the previous case of Rose was followed and applied by the Court of Appeal. The registered owner of shares executed 2 share transfers, one in favour of his wife absolutely by way of gift, and the other in favour of 2 people, including his wife, on trust. The shares were held in a private company which empowered the board of directors to object to the transfer of shares. Again, the transferor had completed all the formalities required of him. Only ratification by the board of directors remained before the transfer was complete. The date of transfer was again important so that Rose's estate could demonstrate that the voluntary transfer had succeeded in passing an equitable interest in the shares to attract a lower rate of tax than would otherwise have been payable if the transfer had not taken effect until the date of ratification by the board. The argument for the IRC was that there was no transfer until ratification as provided by common law, and that there could be no suggestion of an express trust having been created because that would be to give effect to the intended bequest by means not intended by the transferor. The Court of Appeal here then approved the decision from the 1949 case of R.E. Rose and held that the equitable interest in the shares had been transferred as soon as the transferor had completed all of the formalities which he was required to complete. In other words, as soon as the transferor had completed all the formalities he could do, there was a constructive trust over the shares. Okay? And the principle requires that every effort has been made, and so as long as every effort has been made by the transferor to transfer whatever it is, then that will be enough. That is why we call it the every effort rule. If the transferor purports to make a gift but omits a step, then the principle set out in Milroy and Lord applies. So a failure to hand over the share certificate as well as a share transfer form would prevent the every effort rule from applying. So Milroy and Lord said that an ineffective gift does not constitute a declaration of trust. And this principle in Milroy and Lord will apply if every effort has not been made and a step has been omitted. In Milroy and Lord itself, the agent had not completed all of the formalities necessary to achieve a transfer of the property. In the 1952 case of Rose, the second case, Lord Evershed held that all of the actions necessary to be taken by the transferor to effect a valid transfer had been carried out, such that the court considered that it would have been against the conscience of the donor to go back on his intention to make a transfer of the property. Okay, so that is the second case of Rose. And we also have a case, a bit more recently, of Pennington Wine from 2002. And this case has been criticised by academics because the every effort rule in this case was not applied. Rather, a wholly novel position was established in this case. It was said that an ineffective transfer will take effect in equity where it is unconscionable for the transferor to change his mind. So in this case, we have a donor who is called Ada Crampton, intended to transfer 400 shares in the private company to her nephew Harold, and to have Harold made director of the company. Now, Ada completed a share transfer form from which she sent to her accountant Pennington, but Pennington failed to forward this form either to the company or to Harold. And Ada subsequently signed a form consenting to Harold becoming a director of the company, but by her will she transferred him insufficient shares to Harold to have a controlling shareholding in the company. If Ada had transferred the 400 shares to Harold before her death, then Harold would have had such controlling interest in the company. And it was held by Judge Arden that an equitable interest in those shares passed to Harold because it was considered that it would have been unconscionable for Ada to have refused to transfer those shares to Harold. And he said, if one proceeds on the basis that a principle which animates the answer to the question whether an apparently incomplete gift is to be treated as completely constituted, is that a donor will not be permitted to change his or her mind if it would be unconscionable in the eyes of equity vis-à-vis the donee to do so, what is the position here? There can be no comprehensive list of factors which make it unconscionable for the donor to change his or her mind. It must depend on the court's evaluation of all the relevant considerations. So, whereas the every effort rule is an equitable rule that would apply automatically if the transferor made every effort to transfer the property, this rule appears to give the court discretion and wide powers to decide whether or not it would be the right thing to do to complete the gifts. Okay? And so, as I said, this case has been criticised for introducing what appears to be a discretionary element of the law. Okay? And it is difficult to disagree with this view that the court has given itself an unfettered discretion to give effect to ineffective transactions if it would be unconscionable not to do so. And honestly, we don't like this, okay? Equity shouldn't have a discretionary jurisdiction, okay? We are particularly unhappy about the court's last sentence here, okay? It must depend on the court's evaluation of all the relevant considerations. Today, equity is very much rule-based, and we have moved away from the time in which it was discretionary. The court's decision in this case is vague, and equity shouldn't be vague. And I've explained this in a lot more depth about the history of equity in my first video in this video series on equity and trust. And so if you want to learn a bit more about the background of equity and trusts and how we've got to where we are today and moving away from the discretionary sort of jurisdiction of equity, then check out those videos, and that does explain it in a lot more depth. And in the more recent case of Kay and Zeitel in 2010, the Court of Appeal took a more orthodox approach. In that case, it appeared that the share certificate was missing. The Court of Appeal held that the donor had it in his power to obtain a copy of the certificate, whereas the donee did not. By taking steps to obtain the copy, the donor had not made every effort within his power, so the transfer failed. So in this case, the Court of Appeal took a more hard-lined approach to applying the every effort rule. In other words, the donor had not made every effort, so the transfer failed. Okay, so that is the end of this video, and that means we've now covered three aspects where equity is going to step in, where equity will allow the transfer of legal title to occur, even though the formality requirements of doing so have not been completed. We've covered conveyance of land to a minor, gifts made in contemplation of death, and the every effort rule. And in the next video, we're going to be looking at the rule in Strong and Bird. But if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.